So I should start by saying, I'm sure you were wondering when you saw the sheet earlier who the person was with the completely unpronounceable name, as well as wondering how did she wangle her way onto this very impressive panel. And I do often get asked how to pronounce my name. I'm hugely impressed with Atalanta managing to pronounce it properly today. I often get asked if my parents dropped a bag of Scrabble tiles and then randomly arranged the letters to create my name. When I was acting a number of years ago in the 7/7 inquests, one journalist with a rather enthusiastic spell checker did a report which said, Barrister Caoilfhionn Gallagher submitted. So I'm affectionately known at home as Caoilfhionn Gallagher on a regular basis. I should also say, you will have seen me coming in late. I'm very grateful to the organisers for agreeing that I could come in late and be slotted in at the end. And that's quite a good insight, I think, into our lives, because despite having got up this morning at 4 a.m. to get everything cleared, having worked for a number of hours to then have breakfast with my very young family, and then coming into work, at 5:15, I end up getting papers sent in outrageously late by the other side in a very urgent appeal, which has been ordered into the Court of Appeal at 24 hours notice. And unfortunately, that's just an aspect of our lives. Exceptionally urgent things come in. It doesn't matter how you plan your time. And of course, the court will be very critical of how the other side behaved in that way, I would expect. But you've still just got to get on with it. You are in the position of saying, well, we are where we are. I've got to turn up and I've got to present my case for my client, despite the fact that it's arrived outrageously late, and you just have to get on with it. So arriving in late in the way that I did is a good insight, I think, into one aspect of our lives. What I was going to do was just cover briefly, firstly, just some aspects of the perception, although that overlaps a lot with what Mavis has done in a way that I never could. Mine was just some brief indications of how people perceive lawyers. And then I was going to give you some indication in the short time that I've got about the reality for me, just a snapshot of my particular field, my particular circumstances, some examples of the nature of the work, some particular cases and clients. And then finally, I just wanted to deal, particularly in light of the fact that people have talked about lawyers not identifying with causes, and with the fact that I am a lawyer who's very much identified with causes and does do wider campaigning work, does do a lot of pro bono work for particular groups of people, for women, for individuals worldwide who are held in conditions amounting to torture and so on. And I would like to just deal with that issue towards the end quickly. So on perception, the next one. I thought Mavis mentioned earlier that lawyers are often considered mercenary, money-grabbing and dishonest. I've noticed that we have the dubious honour of regularly featuring on most hated profession surveys, the kind of August sleepy season piece that's rolled out by a number of newspapers, and other professions which tend to be listed. This is the company that we keep. Bailiffs, estate agents, spammers, politicians, used car salesmen, tax inspectors, traffic wardens, and telephone salespeople, particularly those who call at very inconvenient times. And obviously, you'll have seen many very bad, usually not particularly amusing lawyer jokes, which all work on the basis that we're money-grabbing, dishonest, and so on. There is some interesting analysis, I think, some discussions that I've had with colleagues about why you get these negative perceptions. And I think often, in many of the fields in which we work, we're dealing with clients in circumstances where it's the worst possible time of their lives. They've often been landed in a situation where they've got to deal with lawyers. The law in those situations is not something that's going to be a positive experience for them, and that may perhaps contribute to it. One lawyer said this, which I think is quite a good way of describing it. People only need lawyers when something has gone wrong, often because they've buggered it up themselves. So they resent needing us and having to admit it's gone pear-shaped, particularly in family law when both parties want someone else to blame. They also have no idea what we actually do. They don't get that the years of training and experience which permit a doctor to say, ignore it, it's fine, or you need an operation, are essentially the same skills which we exercise as barristers. And they certainly don't understand the hours of preparation required for what may end up being a very short application in court, or an application which may go away, or that small cases in money terms can be far more legally complex than larger cases. And I think as well there's also some truth in what people say about, often you get people saying that they dislike lawyers generally. Oh, no, not yet. You often get people saying that they dislike lawyers generally, but not dislike lawyers generally, but actually saying that their own lawyer in their own cases that they've dealt with they quite like. So they have this general perception of dislike, but their own experience has been quite positive. The next one, if that's okay. I had some quotes there on quotes about how unpopular lawyers are. I won't go through them given the time. I think some of them are quite nice. You've seen the Joyce Carol Oates one there about a lawyer is basically a mouth. Like a shark is a mouth attached to a long gut. The business of lawyers is to talk, to interpret, to interrupt one another, and to devour each other if possible. But there's a whole range of circumstances in which you get quite negative discussions about lawyers. It is also interesting. I just included here some kind of Google images of what shows up for barristers. And the picture which you'll see on this one and the next one is primarily a pale, stale male type perception. There is one younger woman down towards the bottom left. It's no surprise that that's a recent story about legal aid cuts, because as we know, of course, many of the legal aid cuts disproportionately affect solicitors and barristers who are female, because the areas where they've been hit most hard are areas which tend to be more female dominated. So that's just a little quickly about perception. Could I just move on to, after this, some more images? Just some aspects of the reality. So I've given you on the next slide a description that I quite like, which essentially says that barristers are professional problem solvers, which is a description that I quite like. I often find it's difficult to explain my job. I've got very young children, they're all age 7 and under. And my daughter's description of what I do is she says, Mammy wears a wig and helps people. And I quite like that description, kind of superhero in a wig type description. But it is quite hard to explain our job to very young children. Dr. Justine Rogers, in her slide, in her presentation earlier, described barristers' life as enabling and fulfilling, but also onerous and damaging. And I've just got a good example of that, I think. But also, I think it really encapsulates why our clients are so important and why the work we do is so valuable. So when I was doing the 7/7 inquest, I was heavily pregnant, I had a very young child, and my partner as an academic was working in Sheffield, so I was travelling up to Sheffield midweek. So I was at home, getting up again, 4:35 a.m. in the morning to work before getting my daughter up, and a hugely difficult thing to do. And then when you go into court and you're representing people who've lost their children in this atrocity, I mean, that's what really reminds you when you go home that why what you're doing is so important. Similarly, when I travel up to Hillsborough, you're travelling away from your family, you're going to the other end of the country. But I'm dealing with people who had a son who went to a football match and never came home. And I actually think there that sometimes your family life and the fact that you're missing your children when you're away and when you're working like this can actually really drive you to do a better job for your clients, because you really understand what they've lost and how horrific the process is that they're going through. And just in terms of the nature of the work that I do, you often get with people who do human rights work some high-profile headline-grabbing cases, but the work which I find most rewarding is work which is never seen. So it's work like, some of you may know about a duty judge. There's a 24 hours a day judge who sits in the High Court, and if you ever have something urgent, there's a plane, someone's about to be deported and they shouldn't be, you can call. Something's due to go out on Panorama and it shouldn't be, you can call the duty judge at the High Court and make an application. And I often have to do that in situations which sometimes are life and death, but often concern street homelessness of a child, where in fact there's a very clear obligation on a public body, on social services, to provide accommodation to a child who's street homeless, and the public body simply has failed to do it. And you get to the end of the day, they haven't done it, your child is going to be on the street overnight unless you take action. And you've got to do this duty judge application, you make a telephone call, you speak to the judge, you certainly get to see the humanity of the judge in those circumstances, because quite often they'll say things like, well, I don't use email myself, but my wife does, or they'll start to tell you things about their dinner and so on. It's quite difficult to remember you're making a formal application in these circumstances, but it's quite an informal medium, speaking on the telephone in that way. Now, many of those cases, so cases about street homelessness, cases where there's been separation of mother and baby unlawfully, or cases where, one of my recent examples is a situation in which a prisoner who was very vulnerable, who was methadone dependent, was in a private prison, and the private prison took a view that as a punishment, a disciplinary punishment, they would stop his methadone. And there's very clear evidence that removal of methadone is linked to suicide risk. It was plainly a life and death type situation. And in all of those cases, the public body, many of those cases, the public body caves, and caves very quickly, because what they've done is unlawful. You get rightly interim relief from the duty judge, you protect your client, and the case goes away and it settles. Now, outrageously, those types of cases, if they've settled prior to what's called permission stage in judicial review, are now officially treated as failures. And you will see when you read material from the Ministry of Justice over the last couple of years that cases which have been issued and haven't resulted in a win at court are described by the Ministry of Justice as losses or as cases that have failed. And that includes these kind of cases where public bodies have behaved outrageously. And you have to go to a judge at 2 a.m. or 8 p.m. or whatever time it is to get an order, to get them to do what they should have done in the first place. And it's really quite disgraceful, I think, when you look at the legal aid cuts, that one of the premises of legal aid cuts for judicial review pre-permission, to use the technical phrase, works on the basis that those kinds of cases are failures. I mentioned earlier that often you're dealing with clients at a particularly low point in their lives. Inquests are a good example of that. Completely baffling system for many people. They've been thrust into this situation, they've never asked for it. The death is often very unexpected. And in those cases, the stakes are very high, both in terms of getting answers for your client, but also many of my clients in inquests feel very strongly about getting changes made so that other families don't have to go through what they went through. So if there are systemic failures, they want them identified and they want them changed. Now, Justine spoke earlier about humiliation and the pupil barristers being concerned about humiliation. For my part, I don't particularly care about being humiliated by the judge. I care if I'm not doing my job well and if I'm not persuading the judge and if the humiliation is a factor of me not doing my job well and because I failed to persuade the judge. But really, I think our job, we're a conduit for explaining our client's point. And I don't feel, I may perhaps have felt when I started in the job that I was focused on how I presented and whether I was humiliated and so on. But now I feel you really need to focus on whether you're doing the right job for the judge. Now, Robin said earlier about the colleague who said, well, now doing civil work, it's not like crime, no one's going to jail. Some of my colleagues at Doughty Street who've done Caribbean and African death penalty work say that's a huge pressure, obviously, when you're doing, when your advocacy is literally something on which a man's life depends, almost always a man's life depends. And your submissions can be hugely important. You can make a huge difference in those kind of cases, street homelessness cases, whole range of cases. Just quickly, given the time, I've included on the slides just a little bit of information about the case that was referred to earlier. I won't go into the detail of it given the time. It just was to give you an example of how really our clients are quite incredible. And also it's important to remember that while the barrister is the performer, the really important people here are the clients. And this case was an example of a 17-year-old who stood up and decided to take this case to court. And I'm quite proud to live in a country where a 17-year-old can say, well, I was held in these circumstances. It was wrong that I was held in this way. And I'm going to stand up. I'm also proud to live in a country where a judge like Lord Justice Moses is quite happy to tell the Home Secretary when she's got it wrong and to order her to change it. So I just wanted to give you that example. Finally, we'll just skip through a few, I think, given the time. And finally, on this slide, I mentioned wider campaigning work earlier. And I don't really like the idea of detachment in some senses. It is, of course, right that you need to be neutral, present your case, not become emotionally involved, and therefore not do your job as well as you should. But I do think there's very different skills in constructing an argument and being on the other side and destructing an argument. And there's good reason why many people are specialist claimant barristers or specialist defendant barristers. There's not very many people who can do both sides and do it well. There are some notable exceptions to that. You do see people who've developed specialist skills on one side or the other. And similarly, when you've had the privilege to work with clients and NGOs such as Women's Aid or Just for Kids, who do really quite amazing work with people who are very vulnerable at very difficult times in their lives, I think as lawyers, we should consider getting involved in wider campaigning. And this is why I gave this example here. Many of you will know that the Human Rights Act is often treated as if it's a kind of bad phrase, rather like health and safety or political correctness. And what I've done with a number of my clients, and my clients are to the fore, this isn't about lawyers, it's about the clients, over the past number of months, is we've started a campaign called Act for the Act, to try to tell the public why the misperception that the Human Rights Act only protects criminals and terrorists is wrong, the misperception about Theresa May's cat is wrong, and we wanted to tell real stories about people who have used the law and used the law effectively. So I've just got 2 slides at the end. Could we just go back to the other ones quickly? Sorry. So this one these are parents of a 17-year-old girl called Cassia, and she's one of the people who took her own life after being detained in circumstances where she was treated like an adult and wasn't given additional protections. She was held in a police cell for 3 days in circumstances where, if she'd been 16, she would have been transferred to social services accommodation. And she now, as a result of her death, her parents have campaigned to change that aspect of the law. It was changed a number of weeks ago, and they have decided to go public, tell their story, and say this is an example of what the Human Rights Act can do and what the law can do. It's a positive story about what the law can do. And then the next one, which I had, and this is the final one, is a gentleman called Mark Neary. And Mark Neary is again a very good example. One of my colleagues, Sweeney Rathne, did this case. So Mark Neary's son was removed from him and kept hundreds of miles away in circumstances which the court found were very clear breach of his son's right to liberty under Article 5 and the right to private and family life of both of them, and his son was returned. And again, he's someone who's wanted to tell his story. He's had a very positive experience of lawyers, very positive experience of barristers, very positive experience of the Human Rights Act, and he's wanted to tell that story publicly. And I thought it was helpful just to give that wider aspect rather than just speaking about our own individual cases. I hope that's helpful.